If you're running a services business and you think contracts are just a paperwork, you are literally gambling with your livelihoods. One small sentence hidden inside that contract can literally wipe out your profit, tie you up in courts, and even sink your entire business. And I am not guessing. It happened to me. I followed the rules, I did work, I even won a judgment, and I still lost tens of thousands of dollars I never got back, not to mention enormous stress, time, and energy it consumed. If you do not know what to look for, it is not a matter of if you will get burned. It is a matter of when you will get burned. I had a client who owed me about $13,000 plus. We stripped and waxed floors for a large national retailer. So the guy was hired in between the retailer and me because he was a subcontractor and I was a subcontractor. So his scope of work included installing the floors as well as refinishing the floors. And for the refinishing part, he brought us in. We completed 3 stores in 3 different states. So as you can imagine, I had to hire crews across the state, like search, hire, train, make sure that my manager moves there, pay for all the hotel expenses, travel expenses, lodging, food, and etc. All out of pocket, only to find out later that this client had zero intentions of paying. He paid though, first 2 small invoices to just earn my trust. And then now I can see it right in hindsight. But then when the big bill came in due, he literally vanished. And what made it worse, during the entire process, the guy kept telling me this partnership was made in heaven. So much so for someone who believed in a higher power. Now, let's make sure this never happens to you, because it's really, really hard to come back up on your feet after this. Here is a quick disclaimer. I'm not a lawyer. I'm a cleaning business owner who learned the hard way by losing real money. This is not a legal advice. Always have an attorney to review your contract. Yet today, I'm going to show you exactly what red flags you should spot before you even sign a contract. Quick tip, how to read contracts fast. What you want to do is scan the headings, get the sentence off the sections, find keywords, search for terms like law, jurisdiction, identity, renewal, etc. to jump to crucial clauses. Spot red flags. Mark any clause that looks risky or confusing. Just write it, underline it, ask questions. If something unclear or seems unfair, ask for clarification or get professional advice before signing it. And now that the technology is out there, take the verbiage, drop it in GPT. If you don't understand, then say, explain it to me in layman's terms, and it will do its really good explanation for you. Do this and you will catch most issues really early. Now, let's get on to the traps. Trap number 1, that's a governing law and jurisdiction. What is it? In plain English, the clause decides which state's law govern the contract and where any disputes will be handled. It's basically naming the home court for legal issues. And why is this a trap? If the contract picks the client's state, not yours, which had happened in my case, you could be forced to resolve dispute far from home. For example, your business is, let's say, in Florida, but the contract says New York law and New York courts. If a conflict comes up, you might have to hire a New York lawyer and travel to New York. That gets really expensive and really fast, possibly more than the money at stake itself. It also gives the other side a home field advantage. And here's an example for the governing law. This agreement is governed by the laws of state of New York. Any dispute shall be resolved in New York courts. And in translation, basically, it says, if there is a problem, it is handled under New York law, in New York courts. If you are not in New York, that is a big hassle and expense. So how to protect yourself? What you want to do is negotiate the venue. And whenever possible, get the governing law jurisdiction set to your state. This way, any fight happens, now it happens on your turf. And if the client won't budge, then at least you know that now you are agreeing to it mindfully. You can factor in potential travel and out-of-state legal costs should a dispute arise. In some cases, You might propose a compromise like arbitration in neutral location. I am in favor of arbitration, and if possible, make it virtual. The key is don't ignore this clause. It is not in your favor. Be mindful of the risks and costs if things go south. And there are in cases when actually my cleaning services takes the contract agreeing to this term. This is on those cases when I have a trust with the company that I've worked before, or I know the company is reputable and big enough and it's not going to go anywhere and it will pay. Because in those cases, the companies will not budge with you. Trap number 2, pay when get paid clause. What is it? A clause that says you get paid only after, highlight, only after client gets paid by the project owner. So for example, a project owner, let's say a T-Mobile store, subs out to a subcontractor, and now you are a subcontractor. Sometimes there's even subcontracts, right? Unless this guy, the T-Mobile, in this case, just an example, pays, then nobody else gets paid. Is this what you want? Why is this a trap? Because it shifts the risk of not getting paid onto you. And if their client delays or never pays, you could be left waiting for a long term for your money or never see it all, even though you've done your part and covered your own costs. For small businesses, that cash flow hit can be devastating. And especially if you're in a cleaning business, then what happens is you're the last trade because they normally hold the retainer. Let's say the company, let's say T-Mobile in this case, is holding the retainer, and until all the other trades are satisfied before you, those who poured the foundation, those who did the mechanical, electrical, plumbing work, those who did the painting, those who installed the doors, alarm system, everything, until this is satisfied, you don't get paid, which means the customer can keep finding a punch list, and your company, not your company, but the company that hired you keeps coming back, addressing this. It can drag out for years. So you literally could be waiting for your money, in worst cases, years. And then in worse case, then you just don't get paid because whatever happened, and this company ditched this company because it didn't deliver up to par. So they had to bring somebody else to complete this. Here's a clause example. Subcontractor will get paid within 7 days after contractor receives payment from the owner. So on the surface, it says, we will pay you in just a week after we get paid. But if the owner never pays, this could mean you never get paid. How to protect yourself? Try to remove or adjust it. For example, add a line that says you will still be paid within a fixed time. 30 days, 45 days, 60 days, whatever you are comfortable with. Make sure you have a cash flow to sustain it, because at that time you're paying all your expenses plus the new expenses because of this project. Otherwise you wouldn't have. And even they haven't been paid yet, you still have to pay everyone else that you have hired. So if they refuse, at least you know to brace for possible delays, and you must be okay with it, knowing that the customer that you're about to work for will pay you. You might also decide to build a little extra cost to cover that risk if you'd like, right? Just charge a little more because you're holding the bag until you get your own money. And if you ever see a clause that says pay if paid, meaning if they don't get paid, you never do, treat that as a major red flag and negotiate hard or reconsider the deal entirely. Trap number 3, overboard warranty clauses. And they're especially so relevant to cleaning companies. And what is it? A warranty clause is a promise about your work quality, like guaranteed to fix issues. And an overboard warranty makes that promise too long or too unlimited, making you responsible for things beyond what is fair. And why is this a trap? For example, a contractor might say, contractor warrants all work for 1 year for one-time job like cleaning. That is unrealistic. You don't want to be on the hook for many months for things beyond your control, like normal wear and tear or other people's mistakes. Such clause could force you to come back and fix the problem long after the job, maybe even someone else caused the issue. But think about it. How do you warranty a toilet of not getting dirty for a year of time? Because the moment it is used, it will get dirty. So be mindful of those. Normally, when I see them, I just scratch them and I initial next to it saying not applicable for my type of business. And usually consumers are okay with it. And here's a clause example for you. Contractor warrants that all services will be free from defects for 1 year. Contractor shall promptly correct any defect at its own expenses. This means for a full year, if anything is not perfect, you have to fix for free or clean for free, even if issue is due to usage over time or someone else's error. And how do you want to protect yourself? As I said, I just scratch it. If the consumer doesn't accept scratches, perhaps do like 48 hours or 72 hours, whatever you feel comfortable giving a warranty, because I understand at times when you're done, the customer needs to come in and inspect the job. Also specify what is not covered, like damage caused by others, normal use when you're gone. And if you guys are finding this video valuable so far, a thumbs up would be appreciated. I'm giving you a minute to do that. And thank you so much for doing this. Let's keep crushing through the next terms. Now is trap number 4, one-way identity clause. And what is this? Identification means covering someone's loss or legal expenses if something goes wrong. A one-way identity means only you identify them. They do not identify you. Let's talk why this is a trap, because it can make you financially responsible for lawsuits or damages, even if you are not entirely at fault. And here's an example. Suppose someone slips on a wet floor after you cleaned it and they sue your customer. A one-way identity clause would force you to cover all the legal costs and payouts. And meanwhile, if the client's own negligence caused the problem, they have no duty to cover you. In short, all the risk falls on your shoulders. And even if you had like a wet floor sign, right? Like we had this instance, we actually had a wet floor sign. A person fell and tried to make sure that we pay for all of this. And we had the cameras pulled out and luckily team was using the wet floor sign. So be mindful of this. And here's the clause example. Identification. Contractor shall indemnify and hold harmless client from any and all claims or losses arising out of contractor's work. And in translation, if anything goes wrong connected to your work, you pay for it, period. And how do you want to protect yourself? Make it fair. Try to negotiate the indemnity clause to be mutual. Each party covers the other for their own mistakes, which is fair, right? Or at least add an exemption so you are not covering the client's negligence. For example, change it to contractor shall indemnify client for claims arising from contractor's work except to the extent caused by client's negligence. That way, you are not paying for the client's screw-ups. Many clients will accept that change. Also, ensure you have liability insurance in place. It can help cover indemnity obligations. And the bottom line is read this clause carefully. If it is one-sided and they won't change it, then consider the worst case scenarios and whether your insurance or business can handle this before agreeing. And if you guys are enjoying this so far, a subscribe would be greatly appreciated. Next is trap number 5, automatic renewals with no notice. And what is this? A clause that says the contract will automatically renew for another term unless you cancel it within a certain notice period. And usually there's no requirement for a client to remind you about it. And why is this a trap? It is easy to miss the cancellation window and end up stuck in another term. For example, a 1-year contract might automatically renew for another year unless you cancel 60 days before it ends. And if you forget, suddenly you're now obligated for year 2 on the same terms. You lose the chance to renegotiate or stop the service, and you might have to wait another full term or pay a penalty to get out. And here's a clause example for it. Term for the renewal. Initial term is 12 months. Thereafter, this agreement auto-renews for successive 12-month period unless either party gives 60 days notice of non-renewal. No one is required to remind you about that 60 days deadline. It is on you to remember. And how do you protect yourself. Try to remove or soften this clause. Ideally, make renewal opt-in, requiring both parties to agree to it. If not, at least shorten the notice period. In any case, mark your calendar well in advance of the deadline so you won't be blindsided by an automatic extension. And some businesses will actually agree to send out reminder notice. If you can get that, great. The key is to never be caught off guard. Either negotiate it out or set alerts so you stay in control of the renewal. And at times it's actually beneficial for you because the contract, if contract is profitable, continue. You don't want to do that. Sometimes you can also bake in the clause saying, because there's inflation every year, right? You want to charge a little more from a consumer to cover your ever increasing cost and expenses. So perhaps you can insert a clause that says every year upon completion of this many months, the contract will go up to this much. And if that works for you, then it's great, right? Here's the next one. Unilateral termination of liquidated damages. And what is this? A clause that lets one side, the client in this case, terminate the contract easy, often for convenience, just because it is convenient for them, while penalizing you if you try to terminate it early. And it often includes liquidated damages, a preset fee you will end up owing if you don't complete the term. And why is this a trap? It basically is a one-sided escape hatch. For example, a contract might let the client terminate anytime within 10 days notice, but if you try to quit early, you owe a hefty fee, let's say $5,000 as a liquidated damages. In short, they can walk away free, but you are locked in or face a big penalty if you leave or mess up. This means if the job becomes unprofitable or the client is difficult, you are literally stuck unless you can pay that big fine. Even a minor mistake on your part could be labeled a breach and trigger that fee. And here's a clause example. Client may terminate this contract at any time within 10 days notice. If contractor quits early or doesn't finish the job, contractor must pay $5,000 in damages. And as you can see, they can cancel on immediately, almost, right? But if you stop, you're now on the hook for $5,000. And how to protect yourself? Push for a balanced termination. Like literally insist that either party can end the contract with reasonable notice. For example, 30 days, and try to remove any one-sided penalty. If they absolutely require a fee for each termination, try to reduce it as much as possible. The goal is not to be trapped in a deal or slammed with a huge fine if you need to get out. And at a minimum, make sure you clearly understand any liquidated damages clause. Negotiate it to be as fair and limited as possible, or factor that risk into your willingness to sign. And again, remember, I am not a lawyer. I'm a guy who's been running a company for 15 plus years and other companies and have been burnt many, many times. And my intent to make sure you learn on my mistakes and do not make these costly mistakes. So, as a disclaimer, consult your lawyer. Don't take it as a legal advice. Here is your trap number 7, vague scope of work. And I see a lot of cleaners actually drop the ball here. And what is this? The scope of work defines that you are supposed to do. And if it's vague, the client might keep expecting more and more tasks under that fuzzy description. And we call this scope creep. And why is this a trap? If the contract just says something broad like contractor will perform cleaning services as needed, the client could argue that includes everything and everything. Windows, sidewalks, you name it. You could end up doing a lot of extra work for free or arguing about it back and forth. Without a clearly defining scope, you and the client might have very different ideas of what is that and what that specific job includes. And that leads to conflict or unpaid work. And here's a clause example for it. Contractor will perform cleaning services as needed. An extreme vague would be as needed. Could be interrupted to include all sorts of tasks. How to protect yourself. Make sure to spell out the scope in writing. We do it by bullet, line by line. Include something like tasks not listed here are not included and may require an extra agreement cost. That way, if the client asks for more, you can now point out to the contract and say, here it is, and either negotiate or change order for extra, or politely decline because it's not a part of your deal. Or you could actually decide to take this and show them a goodwill, because then you put a check mark in that customer's piggy bank, a goodwill piggy bank, that you did something extra that you weren't supposed to be paid for. That now warrants a good referral, another extension of a year, a great testimonial, and everything else amazing that comes with it. The clearer the scope, the less room for surprises. It protects both sides by aligning expectations from the start. Trap number 8, no dispute resolution clause. What is it? A contract with no clause on how to resolve disputes. That means if you and client get into a serious disagreement, there is no preset process like mediation or arbitration. You're likely heading to court by default. And why is this a trap? Without a dispute resolution clause, even a small conflict can escalate to a lawsuit because there's no step-by-step resolution path, right? Lawsuits are very expensive and extremely slow. For example, if the client refuses to pay you and there's nothing in contract about how to handle this, your only option may be to sue them, possibly in their state. Remember that trap from number 1? Or if they claim you did something wrong, they might drag you into court. This can now burn a lot of time and money for both parties. And if they are big company, because usually we're cleaners small and we work for huge companies, they will eat you up, won't even digest you, and spit you out. And here's the example for that clause. Any dispute arising under this contract shall first be mediated in good faith. That's what you want. If not resolved, the dispute shall be settled by binding arbitration. This clause forces both sides to try mediation, then arbitration, instead immediately suing. And how to protect yourself. If a contract lacks a dispute resolution clause, consider proposing one, because sometimes customers are not trying to take advantage of you. Sometimes they just don't know. Even a simple agreement to mediate before any lawsuit can be a lifesaver. There's a huge cost difference between going to court, mediating, or arbitrating. Like, huge cost difference. Many clients are open to this because it's fair. Low cost approach. If they won't add one, just be aware that any serious dispute might head straight to the court. That means you need to be extra diligent in keeping records, emails, change orders, etc., communication, and perhaps be ready to involve a lawyer, which means you need to have a lawyer in your court. Having a dispute resolution plan in the contract is like having insurance. You hope you never need it, but it is sure nice to have it if a fight breaks out. Now let's talk about the quick tips how to protect yourself. To wrap up this contract traps, there are some general tips to help protect yourself. Read every contract and use checklists. Don't assume anything is standard in this world. Go through and check for these red flag clauses we discussed: governing law, payment terms, warranty, indemnity, renewal, termination, scope, dispute, negotiate, or clarify terms. And if you see an unfair clause, talk to the client about it. They may agree to tweak or remove if you ask politely. It never hurts to ask. And in most of cases, in my cases, clients were willing to work with me. That's in most cases. If somebody is not willing to work with you, that is a red flag from the get-go, from the start. Just be mindful of it. Put in writing and track dates. If you agree on any changes on specific conditions, get them in the contract or as an addendum and have both parties sign. Worst, you can do like a warranty, like I do, scratch it and initial it and have customer to initial next to it as well. Also keep a calendar of key dates like notice deadlines so you don't miss them. Written agreements and reminders will save you from he said, she said situations, which are worse. And we know that. Get help or walk away. If a contract is really confusing or contains a potential deal breaker clause, get a professional opinion, have lawyer review it, or be prepared to say no to the job. And sometimes the best decision is not to sign a bad contract. Now, my friends, you have made it through the contract boot camp. It was a lot, but now you are equipped to spot these red flags and protect your businesses. Remember, contracts are often negotiable. Most clients aren't out there trying to get you. They might just be using templates and haven't thought about how it would affect you. By bringing up reasonable concerns, and there's nothing unreasonable that we talked about, you can often create a contract that's fair for both sides. The peace of mind from a fair contract is worth it. You can focus on doing a great job, knowing you won't get ambushed by a sneaky clause later. And if a client truly values your work or yourself, they will be willing to tweak a contract so that both of you feel good about it. As the next step, feel free to download the red flag checklist on my website, ansimpact.com. I've prepared it, and the link will be down in a comment. It summarizes these common traps on one page, so you can run through it whether you are about to sign a new contract or not. Make it small print and put it in your wallet so it's always with you, because these terms are kind of universal for any services contract that you would be executing down the road. And don't sign any blindly. Use the checklist to make sure you are not missing any of these red flags. And if you found this helpful, please share it with other business owners or contractors who could use this information. We should all help one another avoid bad deals and building stronger businesses. And thank you so much for watching it, and good luck with your contracts. Now you can sign with confidence, knowing what to watch out for. And happy signing on your terms, my friends. And before you go, make sure you watch this next video right here. It shows how fast things can go wrong when someone working for you tries to take advantage and you don't have your legal ducks in a row. See you inside of this video. Bye for now.